It is just about 11 a.m. in Washington, D.C., where earlier this morning, the Supreme Court issued an opinion on a case challenging the Biden administration's immigration policy. The justices ruled that the states who brought the challenge did not have the legal standing to do so. For more analysis, let's bring in senior White House and political correspondent Ed O'Keefe, standing by at the White House, and CBS News legal contributor Jessica Levinson. Jessica, first to you. Good to see you. What did the court decide here?
The court decided, as exactly as you said, that Texas and Louisiana, who are both trying to challenge the Biden administration's policy when it comes to who to prioritize to arrest and deport, that they can't. They can't walk into federal court because they don't have a legal injury to do so. Earlier in this case, lower courts had said maybe a monetary injury is enough of an injury. Texas and Louisiana had said, if you don't arrest and deport more people, it will actually cost us money. And Justice Brett Kavanaugh, in quite a thorough decision, went through all the reasons why he thought that wasn't enough of an injury, and all of the reasons why, based on our standing doctrine, you couldn't give states in this circumstance the power to go into federal court and say to an executive agency, we don't like the guidelines you set. We don't like that you're not arresting enough people.
All right, Ed, I guess this is a pretty good win for the Biden administration.
Right, and in fact, they're going to be especially pleased with what Justice Kavanaugh wrote there, in essence saying that this was an unusual lawsuit and one that the states couldn't bring because, in essence, it's telling the states basically, it's narrowing when exactly they're going to be able to sue. And that's exactly what the Biden administration argued, that states didn't have the standing to do this, shouldn't be allowed, and that they were only coming up with this different policy of prioritizing those with a criminal background or the more dangerous over the entire universe of undocumented immigrants, simply because there's only 6,000 ICE agents who would be incapable of rounding up everybody that should have been arrested under this law. In essence, today, the Supreme Court and the White House reiterating what the White House certainly has been saying on the issue of immigration for years, which is Congress needs to cough up more money, more clarity on the laws, change immigration policy to avoid these kinds of lawsuits. But we've seen no formal response just yet from the White House, other than to know, of course, that they were opposed to it. Notably, we have seen a response from at least one Republican presidential candidate, because remember, they continue to make immigration an issue. Former Vice President Mike Pence saying in part that Texas and Louisiana, in this case, are doing everything they can to enforce security at our southern border, despite the crisis caused by the Biden administration's egregious failure to faithfully execute our immigration laws. And in essence saying he would enforce the law as written were he elected president. Of course, if he were to do that, he would require a lot more money for the Department of Homeland Security to detain and then arrest and deport the tens, if not hundreds of thousands of immigrants that would fall under this law.
So, Jessica, Justice Alito was the only justice to dissent in this opinion. What is your understanding of perhaps why he might have done that?
It was a really interesting dissent. He did not pull any punches from the first line. And what he said is basically, majority, you have this inflated view of the power of executive agencies. And he spends a lot of time on very technical aspects of the standing doctrine that we've talked about. Again, in plain language, what is the standing doctrine? It means that you need an injury in order to walk into federal court, and you need to be able to have some sort of redress if you win in federal court. And the majority here, Justice Kavanaugh said, we've never found that when states are saying executive agency, arrest more, we've never found that there is standing. We've never found that when states say, we're challenging executive agency, your prosecutorial discretion to determine who should be arrested and deported first, that would be an injury amounting to standing. And Justice Alito really takes that on point by point. But what I think is underneath that big argument about the standing doctrine is really a difference in their view of the power of executive agencies. The majority here is saying states basically can't touch what the Secretary of Homeland Security decided to do in terms of issuing these guidelines. And Justice Alito, again, is saying that's an incredibly, I think he used the word inflated view of executive power. And he wants states to be able to go in there and challenge the executive policy, at least when it comes to these types of policies.
All right, Ed O'Keefe, Jessica Levinson, great to have both of you on this Friday breaking this down for us. Thank you very much. Appreciate it.